Welcome everyone to our first ever SERMA webinar. The topic today is the top 5 sports and entertainment risk issues right now. And we underline right now because literally these are stories as you'll hear and topics that are literally going on right now. And that's the entire idea behind some of the education that you'll hear from SERMA. First, I'll tell you a little bit more about the organization, why we started, who we are. So first, our mission at SERMA, and SERMA stands for the Sports and Entertainment Risk Management Alliance. We're a brand new organization. We're just a couple of months old. And our goal, as you see from our mission statement in front of you, is to be the world's foremost resource for information and networking in the sports and entertainment risk industries. We discovered that even though these issues are ones we deal with, those of us who handle insurance and claims and risk and legal issues in sports and entertainment, we realized that while we all discuss these issues internally, there wasn't a lot of discussion out there in the marketplace of these central issues. Even though there are seemingly organizations and amazing organizations, many of which I'm part of, for a lot of different specialty areas, there didn't seem to be one that is dealing with these issues. So off we went and we thought, let's fill that void. You'll see in front of you in a moment our board, and most of them are on the Zoom. I'll humbly say that we've assembled some of the world's foremost experts and leaders in this area of claims and risk and legal. I'm very humbled and proud that they've donated generously so much of their time to our organization, especially as a startup. The reasons that we want everyone who is participating in this webinar to join SERMA, and we'll talk to you a second about how to do that, is because we think that we'll provide a valuable resource in filling the void that we discussed. Again, as you talk about these areas, you realize how much of this is going on in the present and in the moment, and yet there's just not a lot of resources out there that allow all of us to better defend our claims, better handle claims and litigation. So again, through networking and through sharing of valuable information like today, we hope to provide the central clearinghouse, the central database for this kind of information. To join, please visit theserma.org. The membership application is very simple. It takes literally about 3 or 4 minutes, and we'd love to have you as a member. I will introduce you now briefly to the board. A couple of logistical points. Today, we'll be discussing 5 topics that we think are very relevant to the sports and entertainment risk and claims field right now. Because of the amount of information, because of the brevity of our time to cover it, the idea is to cover these topics on a very surface level. We are going to cover, however, all of them in more detail in the coming months. So today is a preview, so to speak, of a more in-depth discussion of each of these discussion topics. Each of them, again, cover very crucial issues in our opinion and based on feedback we've received from our members. So today you'll hear an overview, and then starting next month, starting in June, you'll get a more deep dive into each of these 5 topics. So June will be topic number 1, business interruption. July will be topic number 2, and so forth. So today, hopefully you get a sense of what kind of insight our amazing board will bring to these topics, and then please tune in for a more in-depth discussion, the dates of which will be on the last slide at the conclusion of today's webinar. Hopefully that's not too confusing. We'll go over it again at the end. That being said, I'm going to introduce you really briefly to our board. We've got, again, some of the foremost industry leaders in a variety of different fields. We've got Joe Alvari from University of Southern California, Jason Bernstein, Assistant General Counsel, VP of AEG Presents, Christian Deputy, who's the Chief Sales Officer from the Buckner Company, Dave Dwartz, President, CEO of Helmsman Management, Shalom Sanula, Chief Client Executive, Property and Casualty for USI Insurance, Barry Wexler, Executive Vice President, Risk Management for Paramount Global, Pete Heck, Founder and Executive Vice President, Magna Legal, Zebra Janki, VP of Business Development for EK Health Services, Inc. Simon Kashishian, Vice President, Risk Management, Red Bull, and also board member number two perhaps. Lori Kleiman, Vice President, Legal and Risk Management for Comcast Spectacor. Carlos Curie, General Counsel, South by Southwest. Faith Mason, Director, Global Claims Management, Comcast, NBC Universal Sky. Jessica Meckley, Associate Director, Risk Management for the U.S. Olympic and Paralympic Committee. Shep Messing, Chairman of Major Arena Soccer League, and by the way, a legend in his own right in the field of athletics. Peggy Miller, Vice President, Risk Management, Kroenke Sports and Entertainment. Kristen Nixon, Risk Consultant of the Fairley Group. Sydney Posner, Chief Executive Officer of Claims Exchange. And finally, Brian Rosenblatt, who is my partner at my law firm and also General Counsel for the organization. He's with our firm, Downey & Lenkow. So that all being said, I know I went through those quickly. You're going to hear from all of these experts in a moment. And again, the reason we're discussing these particular topics is because, to steal from one of my favorite shows, Law and Order, they are ripped from the headlines. You have to look no further than your feed or your newspaper or the news to see that these issues are out there every single day, whether it's sexual abuse allegations, whether it is incidents at mass events, whether it's insurance risks, intellectual property issues. These are happening every day all around us. And our goal is to be, again, the central database for these issues, to be a robust and interesting discussion on each of these. As an example, in addition to our webinars, we will be providing as content shorter presentations. So we've done already a couple of vlogs. These are available on theserma.org. The first one we did almost very early on in our organization's life, which is just a couple of months ago, was the implications of the slap seen around the world, right? At the Oscars, when Will Smith slapped Chris Rock, we analyzed some of the general liability and workers' compensation risks associated with that. What happens if someone claims that from viewing the slap, they developed PTSD, for example? Or who are the potential defendants if Chris Rock chooses to sue Will Smith? So that was a really interesting discussion. I think it's available, again, on theserma.org. And then last week, many of you are, I know, following closely the Johnny Depp against Amber Heard defamation case that's going on in Virginia. We thought that was an interesting topic, and we had a world-renowned jury consultant from Magna, Rachel York, and also one of our new members, Brian Kafritz, who is a attorney in Virginia, discussing some of the lessons we're learning as this trial unfolds, both from a legal and claims perspective. So please check those out. They're very short and we think they're interesting. To that point, and then we're going to get to our discussion, we are looking for this kind of content from you. We want to hear from you, our members, our attendees, to see what you'd like us to cover. So please send me an email. My contact info is on the website. It's available on social media. Send me ideas, thoughts, and if you want to contribute to any of our vlogs or webinars, we are looking for that assistance as well. So with that all being said, we're going to jump into topic number one, which is business interruption claims. We're kicked off with Christian Deputy, Jason Bernstein, and Simon Kashishian.
Good morning, everyone. I just wanted to touch on very quickly what the definition of business interruption is for those who don't know, and then I'll kick it over to Christian to speak a little bit about how natural disasters can affect, or what kind of business interruption claims can relate to, like a natural disaster claim. So first of all, a business interruption is pretty simple. It's lost business income stemming from a disruption to business operations. Now you think about, for example, natural disasters like hurricanes, fires, and earthquakes. Lost business income is generally defined as the net income of a business that they would have earned through normal operations but for the disruption. And things like payroll and operating expenses are included in that. Another example of a business interruption claim that comes to mind for me is the little old lady driving her Toyota Camry into the plate glass window of a restaurant or a hair salon. And that's what I think about most often when I'm thinking about a business interruption claim. You see that in the news all the time, but we're talking about things, I guess, from a big picture perspective. And, there's no bigger business interruption, and I'm going to speak on it briefly and again in a few weeks, that I think everybody experienced over the course of the last years, and that's obviously COVID. I'm also going to touch on, from a risk manager's perspective, sort of what the three tenets are of risk management. And of course, we'll talk a little bit about business interruption insurance, which is intended to compensate an insured for the income loss during the period of restoration or the time necessary to repair the physical damage covered or damage to covered property. And this is typically first party coverage. So with that, I will turn it over to Christian to touch on a little bit about natural disasters, and we'll talk again soon. Thanks.
Yeah, thanks, Simon. And, we've picked a few different topics within business income and loss. And let me give you just a little bit of background on what we're going to discuss around natural disasters. When you think of natural disasters, my mind just races to, okay, what about wind, hail, flood, named storm, peril, snow loads, but we've started to deal with a new one that I think's kind of entered the marketplace is forest fire, and smoke has become disruptive and a potential loss of impact to organizations. The traditional business income loss as a result of a natural disaster is important to sports organizations and entertainment organizations, but there's a number of other loss of income type natural disasters that can impact you that I find organizations sometimes don't think about, or might think they're covered under their property policy. The property policy is generally where you would go to find a loss of income resulting from a natural disaster. But some of the things we've run into over time is what about a location that you don't own that's critical to the success of your operation? So maybe if you're a large festival or have some type of event that's very reliant on a lot of traffic coming in from outside of your state, what if the airport was impacted by a natural disaster? Could that have a material impact on your event if something were to happen to an airport, or say a venue? What if the venue that's not yours was impacted? How do we deal with those risks? How do we address that with that contingent piece? I mean, one of the things we always want to look at is, can we manage for that? Are there ways that we could change the venue? Is there an alternative venue? Is there some way to continue with our event or our operation without using the venues that we either own or that we use of others? So those are things we want to think about as we're thinking about natural disasters. Another thought that came to me is, I'm on the insurance side of it. So can we transfer that risk? And what does it look like to transfer that risk? If we can't do it on the insurance, on our property insurance policy, are there other ways to cover that? Can we buy event cancellation coverage? What are the different perils that would impact or trigger that coverage and replace our income if it wasn't covered under the property policy? So those are topics we're going to dive into in more detail when we come to June with related to natural disasters. And with that short intro, Simon, I'll pass it back to you or Jason for some intro into the other topics.
Hey, Christian, if I could jump in, Jason, just with one quick question. Christian, did you find that, COVID was actually, obviously a once in a lifetime event, right, for most insureds. Did you find that most insureds were not covered for that kind of event? And obviously it wasn't something that was contemplated, but how do you think going forward, another COVID, if there is another strain, for example, how will that affect how insurance is purchased and thought of?
Yeah, Rich, it's a great question. Most policies already had a pandemic exclusion on them. So COVID was extremely impactful to so many businesses, and yet it didn't have a big impact on kind of a financial impact on the insurance industry. Yes, there was coverage. There absolutely was some coverage, but it was very sublimited, often to very small amounts. If there was any ambiguity in the language, most insurers have come back now and made sure there is no ambiguity in the language. So it is, you are able to buy some coverage for that on a standalone basis. It is not inexpensive to do so. That might change over time. But by and large, pandemics are, for the most part, an uninsured risk and just need to be dealt with from a risk management standpoint. There are ways, that said, there are ways to insure for it, but they are not found in your traditional insurance policy, like a property policy you would find. And if it is, it's a very small sublimit that would probably not be very meaningful to most organizations.
Great. Jason, obviously your company was significantly impacted by COVID and things like other natural disasters. Can you talk to us about your perspective on how to, what takeaways maybe going forward you have had over the last couple of years?
Yeah, I think, I'll touch on natural disasters briefly and then really get into COVID. We do a lot of outdoor festivals. We do some things at the Rose Bowl. We have the Coachella and Stagecoach music festivals, and almost all of the festivals we work with are outdoors. In California and up in the Northwest around Seattle, the number of wildfires and the impact of smoke is something we're starting to look at, because the fire may not destroy the festival site, but you can be 10, 15, 20 miles away, and if it's not safe to breathe, that can be problematic. We had an event at Dodger Stadium where smoke was blowing through, and at one point we were debating, if we were going to have to shift the crowd or shut some stages down. Fortunately, the winds changed, so we were covered. But with global warming and things like that, we don't anticipate it's going to become less of an issue, and that will probably be one of the hot buttons that we're keeping an eye on over the next, months and years to come. Not a whole lot you can do for an outdoor event, and soccer, football, Major League Baseball, they have the same concerns depending on the location. Another natural disaster we had up in Colorado, they had ground prairies or prairie dogs, and they carry communicable diseases and set up a whole set of interruptions that I don't think anyone really contemplated. The city was able to get it under control, but there's weird things that happen all the time. With regard to COVID, I think probably the most important thing for everyone on this meeting to hear is that no one quite knew what to expect. We're very pleased because when we've got concerts going into people's venues, we've got venues hosting bands, everyone said, if someone catches COVID, what will happen? Some states have safe harbors, others don't. It's probably about a third that do, a third that tried and failed, and another third that didn't really address it. But fortunately, most of the plaintiffs' attorneys that bring about big lawsuits, they all drive nice cars, and they want cases they can win. So, to date, I'm not aware of any COVID-related claims against any venues or concert promoters or sports teams or leagues, because you have to be able to prove causation. And even if you know where you got something, I always think back on the movie, I think it was A Few Good Men with Tom Cruise, where he said, it doesn't matter what I know, it's what I can prove. If you can't prove where you got it, the case kind of evaporates. So from a risk management point, we're not too concerned about the insurance claims, but I've been going out of my way with, when we're negotiating contracts to basically say we're affirmatively not going to indemnify the other party and vice versa, just because it gets a little too complicated. In the states where there's safe harbors, it's less of a concern. One of the other issues related to COVID that we've talked about when it comes to business interruptions is originally we said, hey, if there's a COVID problem, it equals force majeure, and the show would be canceled. As we've become more knowledgeable and we know about vaccinations and testing and spreadability and things, we've basically said, if there's a government regulation, let's talk about what the impact is. Is it impacting the sellable capacity? Does it affect the event operations, admission procedures, things like that? I think a lot of people were surprised. There was a big concert in Las Vegas, and what determined whether they could or couldn't go forward had very little to do with the event and more about how much of the local population is vaccinated, because that's who the attendees would ultimately interact with. And I think Las Vegas didn't mind if you took it home, but they didn't want it residing there. So we've seen a lot of interesting things. So far, the only thing I know is everything we've predicted has been wrong. I remember when we were all debating back in 2020, is this going to be over by the summer, or do you think it's going to go to Labor Day or the end of the year? Regardless of what your guess was, you were wrong. So we'll see how things evolve. Hopefully it stays under control. And, but we got to be aware of it. So we're still addressing it in contracts.
Jason, you're right. Thank you so much, Jason. You referenced A Few Good Men. That's one of the many lessons that a lawyer can learn from that film. Another one is that if you ask a hostile witness the same question enough times, they will crack, which actually isn't true, as we all know. That's only a movie thing. The other A Few Good Men lesson is, I don't want to get into A Few Good Men black hole, but the other lesson is, when I talk to young lawyers about writing skills and, speaking skills, I always tell them, don't be redundant. And in the cross-examination scene of Tom Cruise and Jack Nicholson, he asks them about grave danger. And Nicholson said, is there any other kind? So I always think of that as when I'm trying to write and communicate, just be brief, get to the point, don't be redundant. Thank you all so much for great discussion points on business interruption. And again, we'll be talking about these topics and more in a more in-depth fashion when we kick off our more in-depth series in June. Thank you, Simon. Thank you, Christian. Thank you, Jason. With that, we'll turn to our next discussion. This is one that is always in the news, but yet not talked about a lot from a claims and risk perspective: criminal activity in the sports and entertainment arenas. And I'm speaking of mass casualty events. I'm speaking of attacks in parking lots. Again, if you just flip on the news or check out your Twitter feed, you'll see almost daily examples of these kind of events. And more importantly, an increase in litigation in these areas. So we've got Peggy Miller, Shep Messing, and Lori Kleiman, who are going to discuss some of those risks, some of the claims, and how to deal with them. I believe Shep is going to start off giving us a bit of his perspective, which is really interesting, because Shep, give us just a quick summary of what you bring in terms of experience, because it's a little different from the rest of us. You are, again, as I mentioned earlier, a legend in the field of soccer. Tell us about your background and what brought you to your current position.
Thanks, Rich. Welcome, everybody. I don't know about the legend part, but my partners in crime for this presentation, Peggy and Lori, and I unanimously decided I'll start out by giving an overview, a little storytelling, and then I'll turn it back to my partners who are smarter than me. But I've experienced crime through three different lenses: 20 years as a professional athlete, and then as an agent handling athletes all over the world, now as a chairman of a professional indoor soccer league. I'll start with the most horrific. As an athlete, I competed for the United States at the Olympic Games, 1972. Got a knock at my door at 4 o'clock in the morning. 2 German soldiers with machine guns said, "Are you Shep Messing and are you Jewish?" I said, "Yes." Took me into protective custody with other members of the US team. The Palestine terrorist group, Black September, had scaled the fence, attacked the Israeli compound, ended with 11 Israelis dead. That was 50 years ago. Security at that time was de minimis. We would go into the village in Munich, drink a beer, hop over the fence, wave to the guards. Well, 50 years later, we know what the world looks like. On a much lighter note, as an athlete, and we have plenty of lawyers here, I got sued for everything. I was a goalkeeper. I once played a game at Madison Square Garden. I deflected a shot. It went into the stands, hit a guy in the head. He sued me. I guess he didn't read the back of the ticket stub. I had a woman sue me because she said I let up a terrible goal, which I did. It was a bad goal, my fault. And it ruined her son's 10-year-old birthday party. She sued me. I don't want to get into all those crazy, frivolous litigation. You all know what that's all about. I'll fast forward a little bit. And I don't know why I had the crazy idea I wanted to represent athletes. That's a mistake. Don't ever do that. But I formed an agency with Pele as my partner. We had an office in New York, in Brazil, in London. And eventually we represented 150 different soccer players in 14 different countries. I'll tell you 2 quick stories that illustrate anytime you have money and people and athletes and entertainers and crowds, there's going to be crime. So I fly to London, then I fly to Moscow because I had a Russian player who was playing in Portugal. So I flew to Moscow, negotiated a release because the Moscow team still owned his rights. I flew to Porto, then back to London, negotiated a transfer for that player to go from Porto to Fulham. Then I get on a plane, fly back to New York. And it was a huge contract for this player, national team player. I land in New York at JFK and I get a phone call that he's been arrested selling cocaine in the streets in London. So I fly back to London. I find a defense attorney and I take care of that. The lesson I learned is that for the 150 players I had in different cities, I needed to have on speed dial a criminal defense attorney for my players, right? It's unbelievable what goes on in the world regarding athletes, entertainers, and crime. The last one, and the most serious, was a young player that I had playing for Santos in Brazil. 18 years old, his name was Robinho, a kid out of a movie, the favela, no money, but a superstar. And I was transferring him to one of the biggest clubs in the world, Real Madrid in Spain. And in Brazil, you have the police, you have authority, you have the cartel. Sometimes the police work for both. Well, a day before he's about to sign his contract and become a very rich young man, they kidnap his mother and they hold her for ransom, knowing that this teenage kid is coming into $50 million the next week. So I had to coordinate with Brazil, with the police, with Scotland Yard, with the Spanish authorities. And we actually negotiated Real Madrid to make a payment to those that held his mother kidnapped. Made the payment, released the mother. He flew over and played for Real Madrid. I'll finish with a completely different lens that I have now, because as the chairman of a professional league with 16 teams, 2 in Mexico, I worry about everything. And you know what you have to worry about, everything. And so my big overview now, again, if we have people and money and events and athletes and entertainers, there's always going to be crime. So you have to be diligent and you have to be vigilant. And now I'll turn it over to the smarter ones on my team, Peggy and Laurie.
Thanks, Shep. Really fascinating perspective and so glad to have you join us. Peggy and Laurie, you represent, among other organizations, the Colorado Avalanche, the Philadelphia Flyers. So you see examples of fan violence as part of your job. And I know you've got some insight on how to prevent them in the first place and how to deal with them once they take place. And again, these are issues that you see out there every day. Just a couple of months ago in Mexico, there was a incident at a soccer match where there was a riot and 22 people were injured, many significantly. So these are things that are happening as we speak. Lori, Peggy, you want to give us your perspective on these issues, please?
Sure. So we are seeing more incidents of fan violence, fan on athlete. It's just increasing in frequency as time goes on. Both Peggy and I are risk managers for large arenas, as you mentioned. So there are, a couple things we do proactively to try to stave off some of these incidents or learn. We figure out how to control them when they do occur. Some of which is training of event staff, how to de-escalate a situation for a fan-on-fan situation, who to call in the event a situation is witnessed. I mean, our event staff, they're not police officers, they're not bodyguards, they're event staff, so they're not necessarily, and we don't want them to be willing to throw their body into the situation and risk injury. But they certainly have to know, it's good to know procedures to follow, such as who to call in the event of an incident, whether oftentimes there's police on site, so to communicate with the police to draw them to the situation. Excuse me, proper staffing also helps. So if you have the more staffing and the more officers you have on site, the better. Doesn't always prevent an incident, but certainly the more people who are willing and able to respond, the better. We provide, I know we provided our venue, I'm sure Peggy provides at hers, electronic reporting mechanism for fans. So if there's a hostile fan who's cheering for the opponent, sitting a few rows back, and they're getting, they're verbally aggressive and showing signs of potential physical aggression, we can address that once we receive the report from the fan. Peggy, do you want to add anything here? It's tough to control, I'll tell you. I mean, it's really hard to control, 20,000 people who are in the arena, some of whom are drinking and experiencing the event and having a great time. But again, training and training is one of the best mechanisms for dealing with fan-on-fan violence.
And I think one of the challenges that venues are seeing around the country, well, at least in Colorado, is staffing, especially with the summer season. We have, we'll have an event here, we'll have an event at our soccer stadium, we'll have an event at various Red Rocks, other entertainment venues on the same day. And if we have, say, like a higher exposure show here, or Game 5 of Stanley Cup Finals, we're going to run short on staff. So it's even that much more important to make sure that staff that you do have is trained and really made aware of the situational awareness around the venue and the type of crowd that you're trying to manage in those types of events that are higher risk.
Well, it's interesting too, because when I deal with these kind of claims, and I deal with them a lot, you mentioned that you don't necessarily want your employees to be acting as the police, right? So there's that fine line there between training your staff to adequately deal with these events, but also not having them replace the police, because that involves taking on all sorts of liability that you don't want. And we'll be talking in a moment about risk transfer. It's really important that when you are putting people out there in the arenas as security, they're not taking the place of police, and they're not doing things that police should be doing. That's a really hard line to walk, though, in practical terms, I know.
Yeah, physical contact for our event staff is like the last resort. We actually we ask them not to get involved, but there are times when you have an unruly fan who's threatening the well-being of other fans or event staff, so it's necessary to actually, put hands on a patron. As Shep mentioned, there's lawsuits for everything. Well, we're constantly facing claims and lawsuits of, arising out of those incidents the unruly fan himself. So, if we escort somebody out and we actually have to put our hands on the individual to safely escort the individual out of the facility, inevitably I get a claim or a call from a lawyer a couple of weeks later saying, oh, you put your hands on my client, you caused a back injury, a neck injury, that type of thing. So it's difficult. It's a difficult situation to address. And again, we do the best we can by training our event staff on how to handle, how to de-escalate, and who to call when they witness something occurring.
Yeah, I think one common claim in that circumstance is a false imprisonment claim, right? Inevitably, when someone is detained, even if they're not detained physically, they're going to sue you for false imprisonment. And one thing to keep in mind when you have those kind of claims, and this is common to a lot of the things we're talking about today, a lot of the risks, is what are the damages? Even if somehow that plaintiff can prove liability on that we did falsely imprison them, you got to question what are the damages, right? Without any physical symptoms, without any actual treatment, I always attack those claims very aggressively on damages, because really, what are the long-lasting damages that are worth anything? So we're going to jump ahead to our next issue, which is mass shootings. Unfortunately, a fact of life these days in lots of different areas, but in particular, these involve risks at venues that you've got to deal with. What are some takeaways that our viewers can learn from how to prevent these in the first place and then how to deal with them?
I think that it's tough because you don't know when it's going to happen or where it's going to happen. So the best that you can do is just to, as we mentioned before, make sure your staff are trained to recognize red flags of people coming in the venue, people in your parking lots, people while they're inside the venue. If you have a guy wearing a trench coat and it's 90 degrees outside, that may be a little bit suspicious. I think the other important thing too is to train your staff on the run, hide, fight training. For people just like me, just an everyday person, having that training really means a lot when something is actually going to happen. Hopefully it doesn't happen, but if it ever does, I feel like if you have that repetition, your brain is going to trigger and you're going to know run, hide, fight. The other thing that I would say too is to consider, I don't know if it's a requirement in every venue, NBA venue around the country, but consider social media monitoring services, because if someone is out there on Twitter or on any other type of social media and they hashtag whatever artist is in your building, they can pick those up. And if there's some sort of threat being made, then the venue can be made aware of that threat prior to that person maybe even stepping foot on your property.
That's really interesting. What about terrorist threats? Shep told us about his involvement with probably the most famous case of terror threats in this sports and entertainment venue or arena in history, but similar approach to mass shootings and criminal events. But how are you dealing with this emerging threat?
I'll take this one. So we put a couple bullet points. Terroristic threats it's interesting. It's most helpful if you establish a good relationship with the law enforcement organizations in your area, so that always communication is always key. So you loop in the correct party so that you know how to properly address. You can understand better the strength of the threat, whether it's a legitimate threat or whether it's something that should be addressed but not as big of an issue. It's a tough situation to deal with, because you never want to move forward with something where there's a threat of harm, only to find out that threat comes to fruition. But also we can't cancel. We certainly don't want to cancel every single event for a threat that is just frivolous and not really, nothing's going to come of it. So again, like we try to loop in. We have strong communication with the law enforcement entities in the area. We mentioned forming a relationship with DHS. I don't know, Peggy, what else can we, what else do we do? I mean, we put on there, an emergency evacuation plan. I mean, that's certainly important. It's a challenge to evacuate 20,000 people from a packed arena in a safe and orderly manner, but it's certainly something that we would engage in the event it's necessary.
Well, and Peggy and Lori, it's really interesting because unique to sports and entertainment venues, when you consider or see something, say something, is the people who are seeing and saying something, right? You're not dealing with, an airport situation or a hotel situation. You're dealing with people who are there to have a good time, right? And are sometimes drinking, they're doing other substances. They also may be riled up because of a concert or because of rooting for a team. So that makes things a little more challenging too when you consider the source. You don't want to your point, ignore anything, but you also have the obstacle and the challenge of sorting through what is real and what's not.
Right.
Oh, I was just going to say it's important for everyone to have their eyes open around the venue, inside, outside, in the parking lots, and to have that communication with your command center and law enforcement that is on site so that they can determine whether you're going to need to postpone the event, whether you're going to need to not let anybody through the doors until the situation is resolved. You have to be very fast on your feet and be nimble and ready to pivot at any moment when some threat is recognized.
And of course, Shep, Lori, Peggy, the advice that you're leaving us with is probably good advice for any type of claim, but in particular, things that are important when you're dealing with sports and entertainment, because these events are fleeting, right? They're a finite period of time, and many of the witnesses are not around, right? Inherently, if you're dealing with trying to corral witnesses at a sporting event or at a concert, you've probably only got them for that short period of time. It's not like they're employees, or it's not like they're necessarily trackable that you could go back a week later and find out what they know or what they said. You've got the benefit of technology, of course, but a little bit more challenging when you're dealing with sports and entertainment to perform a detailed and thorough investigation.
Yeah, it's important to have a whole team dedicated to incident response during events, because these are the folks that are going to capture your witness information, talk to the witnesses, actually have eyes on the scene. Without that, you're just going to be paying claims. That's been my experience so far, anyway.
Yeah, we always take the position when we train our event staff annually that documentation is key, right? So the who, what, where, when, put everything in writing at the time of the incident or shortly thereafter, so that memories are fresh and you can request information from witnesses or participants in the event you need it. So documenting is really important. And again, documenting in the right way, right? Like you want to understand from whose perspective the incident report is being written, whether something was witnessed by a staff member. And you just want to, in Pennsylvania, the statute of limitations is 2 years. So, I'm not going to see a lawsuit until 2 years later. So I want to make sure all the individuals involved in an incident are identified with, name and contact information, so that I can later reach out to them if they're no longer employed by us. It's really important to capture all of the information in a document so that you can refer to that later, down the line when a claim or a lawsuit is filed. Also, preservation of security footage. That's generally very helpful to us when trying to understand after the fact what occurred. We don't capture every inch of our venue with footage, but we do capture a good deal of it. So it's always helpful, again, if you can see what occurred as it was occurring. Again, that helps to understand how a situation unfolded.
Rich, I just want to add one other factor, and I'm going to, in the future, ask Peggy and Lori to help me with it, because their organizations are funded. They have money to do all the things that we're doing. As chairman of a relatively new professional league, I am going to the owners right now, trying to get a budget allocated to what I consider probably the most important aspect of what we're doing. That when we put on a game, we put on an event, that it's safe. So money's a factor in that as well.
Well, to that point, Shep, we turn to workers' compensation and general liability. I guarantee you that every organization knows, the head of every organization knows what they're spending on these issues, because it is huge. And again, thank you so much, Lori, Peggy, and Shep, for your incredible insight on criminal activity. We'll hear more from them in our webinar series. They will be in July. We'll give you the date at the conclusion. But we're going to talk a little bit more in depth about some workers' compensation and general liability issues with Scott Burmack and Zebra Janke from our board. These issues, again, are ones that we're seeing every single day, and they present in the sports and entertainment industry some unique challenges. Workers' compensation, which is a large part of my practice, I also handle general liability and entertainment law, but workers' compensation costs are, they're all around us. And in the sports and entertainment industries, again, they're very unique because of the sheer volume that you see. At any mass event, you're going to face potential liability. You're going to face exposure, not just from patrons, not just from customers, but from employees. Astroworld, of course, will go down as one of the biggest litigated events in history. We haven't seen yet the breadth and depth of that. But for every patron that sues, and I think it'll, again, be the largest number of potential litigants in American history, there's going to be not exactly an equal number, but a large amount of workers' compensation claims, right? People who are injured, or importantly, people who are claiming some kind of psychiatric injury from Astroworld or similar events. I referenced earlier our vlog about the slap of the Oscars, right? Will Smith slapped Chris Rock. I think I saw a poll that said about 40% of people who witnessed that are claiming some kind of PTSD. Well, in that group of people are employees, right? People who are in the venue or people who are watching the event from outside the venue as part of their job. Those people will undoubtedly claim a workers' compensation injury from exposure to that event. Now, whether or not those claims have any validity is a different question. I would certainly, if I was defending a workers' compensation PTSD claim from witnessing that event, I would first question causation and then question, like I said earlier, damages, or as we call it in Illinois, permanency. Remember that in any workers' compensation claim, it is the claimant's, it's the employee's burden to prove every element of their cause of action. And if they don't prove those, then they don't win. It's not your burden as the employer, as the defendant, as the respondent to prove anything. So taking that example, if I had an employee who witnessed the slap and claimed PTSD, I would certainly question causation, right? Even though you don't have to in most states, in many states, Illinois, California, have to have a physical injury to have a psychological claim. I would certainly question the causation there. And in any psychological claim, I advise all of my clients to take a deep dive into that claimant's background. Inevitably, someone who's claiming a psychiatric claim from a work-related incident, they have a significant prior history. It's almost always the case. That's number one. And number two, like I said earlier, question damages. Taking the Will Smith example, if you were in the venue, you were working security, you were working for the Oscars, and you witnessed that and you're claiming PTSD, I would question the damages. I would question the permanency. I would question what that case is worth, unless you can prove that you are experiencing long-term permanency, and the word is permanency, from that event, then I would question what that case is really worth. Zebra, can you speak briefly about the need and the importance of diving into prior medical records? That's part of some of the work that you do with your excellent team. How important is it, and why is it important to know everything you can about a workers' compensation claimant when you're defending their claim?
Yeah, so you touched on the causation piece, which really I sit on the clinical side, right? So hopefully the causation piece has been defined, and we recognize that the claim has some validity. But regardless, On the clinical side, there's much information to be gathered. Yes, you have to have a team of people that are sitting beside, ready to support you in your endeavors, both to prove and disprove. And then also balance the equation of what's right and just with compassionate care, right? So the employer has that burden of making sure that employees feel that they're cared for holistically while they're on the job doing what they need to dutifully do to uphold their obligations. And that's the side of the equation we largely sit on, right? So from our perspective, it's having readied resources available in order to do the sifting, to do the finding, to support you or the team in their efforts. But then beyond that, right? So if you do identify that there's a claim present, you have to have supportive resources. You have to have relationships with the group therapists, with trauma therapy. In some cases, it might make sense to have on-site psych support for those directly or indirectly impacted. But the key to all of that is to be able to mobilize resources quickly and make sure that the process is easy and the access to treatment or information isn't delayed. That becomes the paramount responsibility, right? The key to risk management, we've stated here across the board, it's very common thread: preparedness, process, and communication. So each of those elements weigh in here, whether you're on the adjudication side of the claim or if you're on the clinical side supporting the claim.
Excellent. Another really hot area in the field of workers' compensation as it applies to sports and entertainment is the issue of CTEs and brain injuries. And we're seeing, of course, a lot of notoriety over the last 10 or 15 years involving athletes who are claiming that because of their employment with the NFL, with Major League Soccer, with whatever sports organization they were a part of, that their employment with their team and those organizations caused some long-term traumatic injuries. And I defend a lot of those claims. I'm defending a few right now. And again, from a defense perspective, one of the ways to defend those claims is to question, again, both causation and damages. Causation, and this is why, by the way, the NFL, when they settled their CTE claims a few years ago, why it was a relatively small amount of money, right? When you look at the amount of money they settled for and the amount of claimants, it really wasn't a lot of money. And the reason for that was the difficulties in proving causation. To prove that your CTE was related to your time with an NFL team, for example, you've got to prove causation. And the way I defend a lot of those claims is by showing that, listen, this claimant, this athlete was employed by many teams and had been playing football typically their entire life, right? And it's very difficult to prove, even with an expert, to a reasonable degree of certainty, which is the standard, that their relatively brief time with my client, the NFL team, caused their CTE versus the other places they played. So always question causation on CTE claims. And the other thing is, I think you have to question damages, especially where, like in many of the cases I'm defending, the player continues to play in the NFL or in the professional sports league. It's very difficult, in my opinion, just common sense, that you briefly played for my client and that caused an injury. And maybe it did. Maybe it's unquestioned that the accident happened while in the employ of my client, but that you went on to play for other teams. And inherently, these are very physical organizations, right? It's very hard to play NFL football. And if you're playing for teams after you left my client's employ, I'm going to argue every single day, I think quite successfully, that you can't prove that your current condition is related back 3 or 4 teams in the past. Sure. The last thing I'll leave you with in defending player injuries is another concept, which in Illinois, unfortunately, the law is very liberal in proving permanent total disability. The law is such in my state that even if you played briefly in the NFL, there's case law to support that you can recover damages, workers' compensation benefits, for the rest of your playing life. So I've got cases where marginal players, by any definition of the term, are claiming that they should receive benefits, assuming they play in the NFL the rest of their career. That's an impossible concept to get your head around logically when you consider that most NFL careers are very short, and most players, especially ones who are claiming these injuries, are not all-stars. They're not all pro players, many of which were undrafted. So that's a challenge in many states, including Illinois, when dealing with player injuries. Scott, we're going to turn to some general liability issues, ones you deal with every day. An important concept, of course, in dealing with sports and entertainment risk when you're dealing typically with multi-party lawsuits, multi-party claims, is transferring risk, right? We're doing our job when we could shift responsibility from our clients to other entities. Can you talk a little bit about that as it applies to sports and entertainment?
Absolutely. Yeah, you're right, Rich. First of all, I just want to speak to what you said at the beginning of the talk, which is that you'd like all of this to be short and interesting. And I should just note for the crew, that's my nickname. So we should be okay. I know a bunch of you on the call. For those who don't know me, I'm a practicing New York City defense attorney, about 30 years of trying general liability cases. I have seen, basically like many of you on the call, no one calls us when something good happens. So we see a lot of bad stuff from a lot of different angles. And one of my, favorite things to do is be able to shift the risk to some other party. This concept of risk transfer, it's so important because one of the things it signals is that there was some thought put to risk before the incident actually occurred. So if you can get your ducks in a row by virtue of a contractual indemnity agreement or additional insured coverage, then by the time something happens, you are very well situated to tender the defense to someone else and not risk either your own financial bad stuff or even your premiums being increased. If you can shift it to another party who really bears the act of negligence, you're way ahead of the curve. And I think the breadth of risk in the sports and entertainment field is just enormous. I mean, we talk about garden variety trip and fall and slip and falls. We've got falling objects in stadiums. We've got harassment and assaults and discrimination and all of this stuff that can happen with a crowd of 50,000 people or even 100 people. One of the things I think that makes us unique in this industry is that these people who get injured, even if they're not our employees, they are our customers. We want them to have a positive experience, even if they are injured. Unless it is a fraud or some sort of exaggerated claim, I think the position we like to take is that we hope these people will come back to us at some point in the future. There's no real interest in alienating everybody. But I should say for purposes of the risk transfer, it's very easy to transfer risk when you are being held statutorily responsible, although not necessarily negligent. And that happens more frequently in the labor and construction law context. Let's say you are performing a minor repair at something in your facility, and one of your subcontractors falls off a ladder and sues you. You have responsibility under the law, and I'm speaking specifically of New York now. I don't pretend to know all 50 states, but at least in New York, it's what we call a liability without fault statute. So if you are a commercial property owner or property occupier and someone is injured in the course of doing what is considered a covered activity, repair, alteration, demolition, things like that, you as the owner are responsible. 100%. Comparative negligence is not even a viable defense. So in that scenario, it's very, very important to have your contractual indemnity agreement in place. You've got to make sure it does not overreach. There's magic language, which is not so magic. It really is, it involves to the fullest extent permitted by law. You hereby will indemnify me for all incidents arising out of your work. The carve out has to be for your own act of negligence. In New York, at least, as in many states, you can't seek to be indemnified for your own negligence, but you can seek to be insured for your negligence. You can transfer the risk to an insurance company. You can ask your vendor to buy you coverage, specifically naming you as an insured or as an additional insured. The benefit to being an insured is that carrier is not going to disclaim simply because you might have some responsibility in causing an incident. Contrast that with a contractual indemnification agreement, where if someone in New York, at least, can prove you are at least 1% at fault, then your contractual indemnity clause goes out the window and everyone is stuck paying for their own defense and potentially paying for their own indemnity. So there are lots and lots of issues, and I look forward to having an hour to talk about these topics. There's just so much to dive into, but thank you for having me, Rich.
That's what's called in the industry a teaser, Scott. Thank you so much. We're going to turn to sexual abuse and molestation. Again, something that we're seeing, unfortunately, the rise of in both claims and litigation. Jessica from the U.S. Olympic and Paralympic Committee and Shalom from USI. What well, let me just tee up the issue again. We are seeing these allegations come up in both entertainment and sports, globally, not just domestically, right? In cycling, in Australian football, in all of the fields you see here, and in a lot of productions, we're seeing these allegations. So it's something that we've all got to deal with, and it doesn't seem to be getting less amount of claims. There seems to be more. So with that said, how are organizations, you think, structured differently in light of SML claims? Shalom, do you want to jump in on that, or?
No, for sure. Thanks for having us, Rich. It's certainly, as we're all aware, we don't have to look very far to see some of these, lawsuits coming out, and some of them are very hard to stomach at times, right? And so the impact that it has to organizations, I mean, at a high level now more than ever, we have to go beyond, sort of surface level of risk management to protect both the participants in organization, right? It's sort of having more of a proactive approach versus being reactive, and how that relates to sort of sports organizations today.
So we've got in front of us a slide about statute of limitations, and it's really an interesting component of these claims because a lot of states have been extending statutes of limitations for sexual abuse or removing them altogether. And this has a direct impact on defending these claims. And, we see it a lot in defending litigation because the challenge there is, of course, you understand the logic behind removing statutes of limitations, right? It's very difficult for victims of sexual abuse to come forward, and you want to encourage them to come forward even after years has gone by. On the other hand, from a defense perspective, it's very difficult to defend these claims when many years have gone by. Memories aren't as strong as they were. Victims pass away or, aren't willing to come forward. So, Jessica, that's definitely an obstacle or a challenge, I would say, that we're dealing with on these claims.
And it is. I think you highlight the issue very well in that on the one hand, there's a great degradation of evidence over time. Memories also change over time in victims. That's been very well established historically. But on the other hand, document retention is an issue. With some of the recent litigation that has arisen in the sports industry, some of the claims go back to the 1960s and 70s. How are you going to find documentation of these instances actually happening? How is this going to be proven in the court of law? And I think that kind of segues into a more cultural issue and a separation of responsibility. There's a very, very clear separation of ethical responsibility and legal responsibility in this instance.
No question. We'll deal with that in more detail in a moment here. But Shalom, could you talk a little bit more about how the insurance industry is reacting to the rise in claims? And in particular, again, as we mentioned, the removal or reduction of statute of limitations and how insurers are dealing with that new reality.
No, absolutely. It certainly hasn't made things easier for a lot of these sports organizations that I mentioned have to almost get on a more of a proactive versus reactive approach, right? And so we use for amateur sports, for instance, at one point, a lot of us have either been a participant or a parent or a part of an organization or a volunteer, right? And so they're often, sort of mission-driven employees wearing many different hats, to try and achieve their initiative at hand. And then it's about finding the right partner to help you execute on that. And so what we're seeing from the insurance perspective is, we just talked about general liability and workers' comp. Well, sexual abuse coverage is certainly, typically it's a part of your general liability coverage. Now, the trend that we're seeing in light of these sexual abuse claims is that it's, it's sort of being excluded, right? Sort of, from the general liability. And so that just means the extra precautions that organizations are having to take is a lot more stringent today. And so we're seeing rate increases, restriction in coverages, or oftentimes there's no they're not offering coverages at all. And right now, in some occasions, some organizations, both amateur and professional, are sort of at the mercy of insurance carriers right now to sort of, in order to have an organization or this tournament or competition or whatever the case may be, they have to pay these coverages, and that certainly affects, membership at the membership level or membership experience.
It's also important to mention now that, Shalom, you also bring a unique perspective. Like Shep, you're a professional athlete. You're a veteran of the U.S. rugby team, correct? Representing our country in many rugby tournaments. I'm probably not using the exact right term. Also a member of the Seattle Seawolves professional rugby team. So it's really interesting to hear your perspective on these issues as well.
No, I appreciate that, Rich. And, sports is about opportunities and experiences. I think good or bad, you'll get one. I think part of the reason why I got into the role I am in today was certainly, being a part of those different structures of an organization where at the amateur level, at the youth, coming through the ages right up to the professional level to board level. Having that sort of background sort of helps with that, holistic approach when it comes to, sort of giving back to sport in a meaningful way. And, often, participants now, we all played sport, and having this, knowing that, sports was a safe place to play, and we want to keep it that way. And so that's the angle where we look at it from a risk standards.
Rugby players are tough. I mean, maybe for a future SERMA event, in-person event, we'll have a rugby match, and we'll see. Probably not. But turning back to the issue that we talked about earlier, Jessica, I mean, one of the challenges, of course, in this field is that you want to respect victims' rights, right? Zebra talked earlier about the need to make sure that injured employees who are legitimately injured are well taken care of. That's obviously of paramount importance when you're defending these kind of claims, given how sensitive in nature they are. Talk to us a little bit more about that.
Well, and we're not just talking, a legal liability here. We're talking about these claims are often tried in the court of public opinion well before they get to court, right? And so your defensibility is a little different. On the legal side, you do want very strong contractual risk transfer, to what Scott was talking to earlier. And you have to strengthen any contracts with a strong statement against sexual abuse and harassment in any form with anybody your company is associating with. And we put that right in our contracts. To that end, we then tie our indemnification and our risk transfer to that statement. It's very clear at the beginning of the business relationship to add to that legal defensibility piece. But on the ethical side, no, I can't think of anybody that I know personally, and we all know of the people that are responsible for these crimes or this misbehavior. I can't think of anybody who doesn't want to stop abuse. And so we all have an ethical responsibility as a community, as sports organizations, especially if you're involved in the care of children or in the coaching of children. We all have a place to play in this. And so I think you have to, in order to be at all defensible in the court of public opinion, be very clear about your culture and your ethical responsibility to stop abuse.
Very interesting. Well stated. The last issue that you'll be covering in the more in-depth discussion, Jessica, is 4 pillars approach to defending these kind of claims. Talk to us briefly about that, if you would.
So the 4 pillars approach was implemented in the 90s, I believe, by the diocese, the Catholic Church, after the systemic abuse was widely uncovered within their organization. And it includes training, background checks, policies and procedures, and mandatory reporting. Now, I think these 4 pillars, if you will, have provided a false sense of security to a lot of executives, a lot of organizations, because they don't go deep enough. And I'll poke some holes in this for you. Fewer than 10% of abusers ever encounter law enforcement. So we know that background checks alone aren't enough, right? Nearly every abuser in the last 10 years has been background checked and undergone some sort of anti-abuse training. And that includes in the workplace, for sexual harassment against employees and elsewhere. So they don't go deep enough. We have to go beyond the 4 pillars approach and adapt additional risk mitigation measures accordingly. And I think the 4 pillars provide a good basis. All of your policies should branch from this. So if we take the training topic, for example, instead of just training about abuse, where to report, how to report, etc., we need to really touch on what is grooming, right? And it cannot just be your staff being trained. There are initiatives underway now to actually train all participants in sport, parents of children who participate in sport, to understand the signs of grooming and stop it before it escalates into something else. So we, as organizations involved in sports and entertainment, have to take the extra step to ensure that people can recognize these signs, similar to what Peggy was talking about when it comes to mass casualty or terrorism incidents. We need to have a see something, say something type response to grooming. Beyond that, background checks cannot be necessarily, a one and done thing. They have to be done regularly. They have to be done in increasing frequency for different positions in your organization. For instance, a coach, probably a background check every 2 years isn't enough. You need to design your background check policy accordingly to how your organization is designed. So there's a lot to go into here. We can talk for hours on this subject alone, and how those 4 pillars really aren't enough, and how we can increase your legal defensibility and your ethical responsibility at the same time, by protecting victims using your risk mitigation measures.
No, I'll just add on to that, Jessica. I mean, it's safe to say that all sports are professional sports, right? Probably not the athletes, but, it seems like everybody else involved have to take that approach. There are bad characters everywhere, and that's the unfortunate, way of sports right now. And oftentimes, sports organizations are suffering right now in the sense of, it's hard for them to focus on their initiatives right now more than ever. All of their time is going towards insurance or risk management, and it's hard for them to grow as a result, right? And so, and this is something we can certainly dive a little bit more in later, but, what resources are out there right now? There are some organizations right now who are getting punished for, a claim. You talked about claims a while ago, right? And right now they're in new organizations and still on the hook from a perception standpoint. How do we help those organizations change that perception, right? That's something we can certainly, that Jessica's referring to here, that we can dive a little bit more into detail on supporting these organizations, because, they have a new board, they have a new, approach. It's a systemic change ultimately, as Jess touched on from a culture standpoint. And that's certainly something that we can chat a little bit more in depth on.
Yeah, I think it's a really good, I'm sorry, Jessica, go ahead.
No, well, to your point, Shalom, I think for all of us in the sports and entertainment industry, there's kind of a taint to it, right? For instance, I brought this up the other day. My child wanted to do gymnastics very, very badly. It's something that she has wanted to do for years. But after the Nassar issue, I, as a parent, was very hesitant to let her go play, to let her go train and let her try it. And I think that presents a systemic risk in the sports and entertainment industry alone. You don't have an athlete pipeline if parents won't let their children participate because they are afraid for their safety. So this is something we need to change at a grassroots level. And it has to be a top-down and bottom-up approach by both empowering the athletes and the parents, as well as empowering employees at any level to speak up and say something if they see something.
That's right.
Yeah, it's a really great point, and a good segue to the reminder that, again, as Shalom said, you might think of sports only as professional sports. The opposite is true. There are billions and billions of dollars being spent every year in this country and around the world in youth sports. And, I coach for my son's teams. My daughter plays JV soccer. And I have the misfortune of, when I look at these games, when I go to the games, I'm not just thinking of, how to run the pick and roll, but what are the risks? What are the claims? What possible litigation will there be? That's the burden we all, are burdened with in doing what we do. And, just Google right now, umpire attack. You'll see a couple examples this week of referees being attacked at Little League games. It's all over the place. And these are issues that will continue to grow as youth sports become such a huge industry. Thank you so much, Shalom. Thank you so much, Jessica. Incredible stuff. I look forward to hearing more in depth in September. We're also going to hear from some other experts in this area when you speak on on September 15th. Last topic for the day is intellectual property with Joe Alvari and Brian Rosenblatt. Joe, you are the claims manager for USC. That's an interesting job, because running risk and claims for a university is literally a microcosm of every single thing in the world. But now you've got to deal with this added issue of NIL. Speak to us a little bit about the challenges dealing with this relatively new area of risk.
Actually, we haven't encountered any issues regarding NIL. In that respect, I would defer to Brian. Our only concern is that as part of our programs, we enter into agreements with different organizations. For instance, you've got the Pac, it's not the Pac-12 anymore. I forget what it is now. It's a Pac, any event. We have an agreement with them regarding use of images, likeness, etc. And as you well know, all of that is controlled by the NCAA. So I'll defer to Brian for additional commentary.
Yeah, and Brian, for those of our listeners who are not following this, recently, I think it was before last year, the NCAA ruled finally that student athletes can sell off their name, image, and likeness for, monetary compensation. And that's a really new development, because for years, the claim has been that athletes are not getting any part of the multi-billion-dollar industry that is the NCAA's. That, of course, involves some all sorts of new intellectual property issues.
Yeah. Forever and a day, the concept was supposed to be that amateur athletics are amateurs and they're not supposed to be getting paid. But when compared to the value or the money that's being brought in by the NCAA, by the universities, by the teams, raised a conflict. Without getting into all of the background, because I know the time is short, and we'll have more time to discuss this when we do this in a longer format. The NCAA has an interim policy right now that puts the onus on states and schools to follow name, image, likeness rules within the individual states. They're required to ensure that the student athletes follow state and school policies. The NCAA policy allows brands to pay student athletes in exchange for the use of the athlete's name, image, likeness in advertising for products and services. The policy prohibits a pay-to-play format. So the agreement must be for actual work performed for the brand, cannot be contingent on enrollment or based on athletic achievement. The policy also provides that individuals can engage in name, image, likeness activities consistent with state law where the college is located. And the individuals can engage in these activities in states without governing law, without violating the NCAA rules. But the students do have to report the NIL activities to their colleges. At this point, there are 29 states that have passed NIL laws. The first was California in 2019. Basically, the California law, and this is kind of what many of the states are following, is that the NCAA is forbidden from revoking the eligibility of a student athlete who is paid for the name, image, likeness rights. Florida passed a similar law in 2020, which took place in 2021. That's kind of the highlight for NIL licensing.
Yeah, interesting stuff, which we'll get into more in depth in November. But before we move on to our next issue, Joe, you've got a picture of the Coliseum, the legendary Coliseum behind you. Again, we'll get you into the future to talk about the challenges that we've talked about earlier in today's webinar in investigating claims. I mean, literally, what's capacity there? 100, 110,000, something like that. Any game involves 110,000 possible witnesses that you've got to deal with. I mean, I can't even get my head around that, but literally that's what you've got every time you've got a game at the Coliseum. So we'll get your perspective on those issues and the challenges that you face in the future.
Definitely. Thank you.
Brian, let's move on to another really interesting IP issue dealing with sports entertainment, one that is literally in the news every day. We're covering it a lot on another podcast that we have. But It seems these days that anyone who has a hit song is also going to be a defendant in a copyright infringement lawsuit. Dua Lipa, I think Levitating was called the #1 song of 2020 or 2021. That is the subject currently of 2 lawsuits in which other artists are claiming that she basically ripped them off. What are briefly some of the challenges involved in defending those kind of claims?
Yeah, so we have to go back to what the concept of a copyright is. And copyright will attach when we take a new or novel artistic expression and fix it in a tangible medium. So the question becomes, is there something new or novel about what Dua Lipa has used, or what Ed Sheeran has used, or what Pharrell and Robin Thicke have used with Blurred Lines? It is a very specific, very fact-driven question. Courts have been coming down pretty strongly on the concept that you cannot have a copyright in a musical scale, in a relatively standard chord progression. So those claims that somebody owns or created a chord progression, though, that's really kind of being tossed out. A little bit more specific to both Dua Lipa and to Ed Sheeran is allegations that they lifted portions of their songs from other people's works. And we get into a comparison of the actual sheet music, the actual notes, how much is strikingly similar from one song to the other. But then we also balance that against how much of that is actually used. Is this a incredibly short, very minimal similarity, or is this the substantial similarity for the entire song? George Harrison's "My Sweet Lord" was almost a complete copy of I think it was the Supreme song, and he got hit for copyright infringement with that. So, right, Ed Sheeran prevailed on his. One of the benchmarks is there access? Do they have some reason to have heard or listened to or seen this other work that they allegedly lifted from? In Ed Sheeran's case, the court said absolutely not. Dua Lipa, that's where this is going. That will be the dispute coming up, and that'll be the battle.
Brian, the other interesting dilemma is you have to prove intent, right? And it's hard to prove intent. Some of the litigants are claiming that Dua Lipa, stole their song, and some of these litigants released their song 25 years ago and are relatively obscure. So it's a really interesting point. Let's really wrap up quickly with the idea of, again, these are topics that we'll deal with more in depth when we have some time, but record music catalog sales are huge, right? Seemingly every artist right now is selling their music catalogs for tens, hundreds of millions of dollars in some cases. And what you'll talk about in your more in-depth portion is that really at the end of the day, these are just an asset sale, right? It's a more prominent type of asset, but just an asset sale that requires some specific handling. That's what you'll talk to us a little bit more in November about.
Yeah, it's a securities transaction. You have to be doing your due diligence. You want to make sure that you have all the copyrights from all the owners, all the authors, all the publishers when you're making the transfer. But big money, Springsteen, Dylan, Robbie Robertson of the band, Tina Turner, at the twilight of their careers, cashing out on future value. And music publishing companies see the value in streaming for these legacy artists and these legacy catalogs. So they just need to make sure that it's all papered correctly.
Yeah, and it speaks to the global issue of how important, IP is more than ever, and legacy IP, right? I mean, that's what every streamer, every content provider is looking for, is solid IP. And sometimes, the oldest IP is the best. And that's why there's such a value to music catalogs that are sometimes, to your point, 50 or 60 years old. We'll skip over this, but obviously a big issue, cybersecurity and data breach, in particular when it comes to entertainment and sports. We've seen some really high profile examples of data breaches that Brian will cover in more detail in November. I want to open it up to some questions. We've got some in the chat box before we wrap up today. So I think Brian asked earlier, when we were talking about criminal activity, did any processes change as a result of any rulings on legal duties for venues as a result of the litigation from the MGM shooting in 2017? And for sure, I'll speak to, representing a lot of venues and hospitality companies in particular. For sure, they changed a lot of their security personnel, because if you remember from that MGM shooting, that individual who did the shooting really got by security pretty easily. He was hauling in massive amounts of weaponry and ammunition, and it was only through, unfortunately, after the event took place that they discovered this cache of weapons. So certainly from what I've seen representing some hotels, they have changed their policies with regards to what you can bring in and the degree to which they can check your rooms. But at the end of the day, very difficult to do so, right? When you're balancing, we talked earlier about balancing different interests. You're balancing the rights of someone to, rent a hotel room and not do so in a way that will result in this kind of activity. Anyone else have any experience or thoughts on how that event might have changed insurance or claims or any legal issues? And then Carlos mentioned that mass shootings would be a good to explain insurance products available, for sure. Again, as these new risks emerge, they have to be insured. Christian, Shalom, any experience with mass shooting coverage? All right, perhaps something we could deal with in more depth when we have our webinars. Any other questions? We're happy to answer them. If not today, then you could certainly send them to me or any member of our board. I told you earlier that we would ask you to join. The membership application is on our website at theserma.org. Again, if it takes you more than 5 minutes, let me know and we'll fix that, but it really should take only a few minutes. And who should join? Again, we've got a couple of different levels. Folks in the industry who are employers, insurers, TPAs in the sports and entertainment world. You don't have to be, though. You could be someone that wants to work in that area or is interested in that area. And then, of course, we've got another category for attorneys and vendors. We welcome everybody at SERMA. So as we grow our membership, we hope to provide and promise to provide some content that'll make your membership valuable. And again, very importantly, we're looking for content. We're looking for assistance from our members. So please let me know of thoughts in that regard. Thank you for the compliment. And then just save the date. As I mentioned, each of today's topics, while I think we cover them very well, they were just a teaser of more in-depth discussions. We will spend 60 minutes, maybe 75 minutes on each of these topics in more detail from the people who you heard from today and some other leaders in this subject matter. So the dates are in front of you. We've got 5 webinars coming up in June, July, August, September, November. We've also got our first in-person event. That will be our seminar, our first ever seminar in Philadelphia. That will be in October 12th. We are putting that together as we speak. Information will be on social media and on our website shortly. But what our goal is for events, very briefly, is to have very intimate, relatively small events where you can gather with your peers in the industry, learn a little bit, network a little bit, and also be exposed to a venue that is unique to sports and entertainment. So stay tuned for that. We think it'll be really fun, really unique events, and will be of value. With that said, I want to thank first and foremost our excellent board for their contributions today, and to SERMA in general. I want to thank everyone who attended. I want to thank Yvonne for her contributions behind the scenes and putting this all together. And want to invite you again to our next webinar, which will be on 6/16/22. That will be a business interruption. Please check us out at theserma.org and follow us on social media. Thank you all very much.